A father is fighting for custody of his daughter. His lawyer files a brief. The brief contains citations to cases that do not exist. The Alabama Supreme Court finds them, dismisses the appeal, bars the lawyer from filing in that court again without a co-counsel signing off on every document. The father now owes $52,000 in opposing counsel fees because of his lawyer's AI output. Not his mistake, his lawyer's. That case is from last month. This is the Hallucination Files, number 02. And since we published the first episode, the situation has changed. The sanctions record has been broken twice. A federal appeals court has suspended attorneys from practice, and judges are now saying something they were not saying 12 months ago. Using AI is not the problem. What you do after is. When we published No. 1, the foundational case was still Mata versus Avianca, Stephen Schwartz, Southern District of New York, June 2023. 6 fabricated cases, a $5,000 sanction. The moment the profession woke up. At that point, Damien Charlatan's hallucination database at HEC Paris was tracking around 1,300 documented cases globally. U.S. courts had imposed roughly $145,000 in AI sanctions across the first quarter of 2026 alone. The numbers were serious. They were also about to get significantly more serious. 3 things have changed since that episode. First, the dollar amounts have stopped being fines and started being career-ending figures. Second, courts have moved from financial penalties to license jeopardy. And third, the Ninth Circuit, the largest federal appeals court in the country, issued a ruling 6 days ago that every lawyer using AI needs to read. We are going to walk through all 3. With the cases, with the facts. Because this is the kind of content where the facts do the work. In March 2026, the Sixth Circuit Court of Appeals sanctioned 2 Tennessee-based attorneys $116,000 for citing hallucinated cases in their appellate briefs. Read that again. $116,000, split between 2 lawyers, each facing $58,000 in joint and several liability. The court did not stop there. It dismissed the underlying case entirely. The client lost not just on appeal, but lost the ability to pursue the matter further, because the brief that was supposed to advance their case was, in the court's words, almost entirely frivolous due to pervasive misconduct. The Sixth Circuit noted something that is worth sitting with. The fake cases appeared precisely because there were few real authorities that clearly supported the legal argument being made. In other words, the AI fabricated citations because the position was difficult to support. The hallucination was not random. It filled the gap where the law did not cooperate. That is a pattern the panel has seen before. When you push an AI to find authority for a weak argument, it will find authority. It will just make it up. The Sixth Circuit record stood for approximately 6 weeks. A federal court in Oregon then ordered a lawyer to pay $109,700 in sanctions and costs. The brief contained 23 fabricated citations and 8 invented quotations. Not misread cases, not wrong citations. Invented from nothing. The court's analysis focused on 2 things: the fabrications themselves and the lawyer's conduct after they were discovered. We will return to that second point because it is now the central theme in how courts are treating these cases. What the Oregon figure tells you practically is this: the calculation that a lawyer might have made 2 years ago, that AI hallucination risk was manageable and that a small sanction was an acceptable tail risk, no longer holds. The tail risk is now a 6-figure exposure. In some jurisdictions, it is now approaching the cost of a malpractice claim. The malpractice framing matters. Some lawyers are starting to receive inquiries from their PI insurers about AI use policies. That conversation is coming for every firm, probably sooner than the managing partner expects. We opened with this one because it contains the most human consequence of anything the panel has reviewed for this episode. The Alabama Supreme Court dismissed an appeal after fabricated citations were discovered in the brief. The lawyer was barred from filing in that court without co-counsel oversight. Standard outcomes at this point. Serious, but familiar. What was not familiar was what happened to the client. The father at the center of the custody dispute was ordered to pay $52,000 in opposing counsel fees. His lawyer's AI error became his financial liability. The appeal that might have changed his family situation was gone, and the costs of the other side's lawyers, incurred because of the misconduct in his brief, were now his to carry. Courts do not always pass the costs to clients, but they can, and in this case, they did. This is worth raising with your team if you have not already. The professional consequences of AI hallucination fall on the lawyer. The financial consequences can fall on the client. Those are two different risk conversations, and most firms are only having one of them. Before we get to LNU versus Blanche, there is a pattern across these cases that the panel wants to name explicitly, because it is the thing that is turning manageable errors into catastrophic ones. The cover-up is worse than the hallucination. In the Sixth Circuit case, the attorneys did not disclose the AI origin of the errors when the court first raised them. In the Oregon case, the conduct after discovery contributed materially to the sanction amount. In case after case in 2026, the trajectory from citation error to career damage has been accelerated, not by the original mistake, but by what the lawyer did next. There is a phrase appearing in judicial decisions now that was not appearing 2 years ago: lack of candor. It carries its own weight in professional conduct terms. A Rule 11 violation for a fabricated citation is serious. A candor violation layered on top of it is categorically more serious. It implicates the lawyer's fitness to practice, not just their research habits. The lesson the panel takes from this pattern is not just verify your citations. It is also know what to do when something goes wrong. Have a protocol. Disclose early. Do not let the instinct to protect the filing turn a fixable error into a conduct matter. On June 3, 2026, the United States Court of Appeals for the Ninth Circuit issued a disciplinary order in a case called LNU versus Blanche. The Ninth Circuit is the largest federal appeals court in the country. This ruling is 6 days old. 2 California immigration attorneys, Mike Singh Sethi and William Rounds, filed briefs containing multiple non-existent cases, misattributed quotations, and what the court called gross misrepresentations of real cases. When challenged, they claimed typographical errors. They repeatedly denied that generative AI had produced the problems. The court investigated. It found other cases in which the same attorneys had filed briefs with similar patterns. It ordered them to show cause why they should not be sanctioned, suspended, or disbarred. The outcome? Sanctions and suspension from practice before the Ninth Circuit. But the more important part of the ruling is not the sanction. It is this line from the panel's opinion. The Ninth Circuit wrote, "The rules are not violated at the point of research and drafting. They are violated at the point of signing and filing." Read that carefully. The court is not saying do not use AI. It is not saying AI-assisted research is professional misconduct. It is saying something much more precise. The moment you sign a document and file it, you own everything in it, completely, without qualification. The AI that drafted it is not a co-signatory. It does not carry professional responsibility. You do. The court also addressed the cover-up directly. It found that one attorney had filed a notice of errata that swapped fabricated citations for real ones, but did not disclose that the originals were AI hallucinations. He described them only as errors. The court was unambiguous. Swapping a hallucination out for a real case does not correct the prior misrepresentation. The fabrication still happened. Disclosure is required. The Ninth Circuit framed this ruling explicitly as a warning to every lawyer practicing before it. Not a warning to the 2 attorneys, to everyone. Financial sanctions are one category of consequence. They hurt, they are public, they compound reputationally, but they are, in principle, recoverable. License jeopardy is a different category. In February 2026, the California State Bar Court approved a disciplinary agreement for attorney Amir Mostafavi. The agreement included a stayed 1-year license suspension, mandatory ethics school, and required coursework specifically on the risks and benefits of AI tools in legal work. Stayed means the suspension does not immediately take effect. It means it is waiting. One further finding of misconduct, and it activates. In Alabama, the Johnson versus Dunn matter produced something the panel had not seen before in AI hallucination cases. A federal court disqualified a Nashville law firm from the case, referred the attorneys to state bar associations in every jurisdiction where they were licensed, and required them to file a copy of the sanctions order in every pending case in which they were counsel of record. Every pending case, every jurisdiction, every client notified, implicitly, that their lawyer had been sanctioned for AI misconduct. The professional consequences of hallucination are no longer abstract. They are reaching into active matters. They are following lawyers across their whole practice, not just the case where it happened. There is one development from 2026 that has not received enough attention, and the panel wants to flag it because it changes how you read every brief that comes across your desk, not just the ones you write. Courts are now signaling that lawyers may have a professional obligation to flag AI hallucinations in opposing counsel's briefs. This is not yet settled law in most jurisdictions, but the direction of travel in judicial commentary and professional conduct discussion is clear. The duty of candor to the court does not stop at your own filings. If you identify a fabricated case in an opposing brief and say nothing, you may be failing that duty. Practically, this means two things. First, it is now worth running a basic citation check on significant opposing briefs, not just as a tactical exercise, but potentially as a professional one. Second, it is worth having a view on what you do when you find something, because the answer of say nothing is becoming harder. To defend. The panel will return to this in a future episode. It is a live area, and the rules are still forming, but you should know it is forming. Damien Charlatan's database is now tracking well over 1,400 documented AI hallucination cases globally. At peak periods in early 2026, his team was recording 10 cases from 10 different courts on a single day. The practice areas being hit are not exotic. Personal injury, commercial litigation, family law, bankruptcy, employment, immigration, consumer protection. Every major area of practice has documented cases. The AI tools involved include ChatGPT, Claude, Gemini, Copilot, and a significant number described only as unspecified AI tools. The panel's reading of this is that lawyers are using AI research tools embedded in products they already use, without necessarily realizing that those tools carry the same hallucination risk as any standalone model. The firms are not exclusively small. Gordon Reese, Boyce Schiller, and Law 100 firms have appeared in the documented cases. This is not a solo practitioner problem. It is a profession-wide problem that happens to be hitting solo practitioners hardest because they have less infrastructure around review. The sanctions trajectory tells its own story. $5,000 in 2023, then warnings, then 5 figures, then 86,000, then 109,000. The floor keeps rising. The ceiling has not yet been found. The panel wants to be direct about what we think the practical takeaways are from everything covered in this episode. First, the verification question is not optional anymore. It has not been optional since MEDA in 2023, but the number of lawyers treating it as optional has clearly not dropped to zero because the case count keeps rising. Every filing that contains AI-generated research needs a human verification step before it goes out. Not a skim, a check. Second, the cover-up instinct will hurt you more than the error. If something goes wrong, the cases are unambiguous on this. Early voluntary disclosure is treated differently from discovered concealment. Know that before you are in the situation, not after. Third, your juniors are carrying your risk. The Ninth Circuit ruling was explicit that the violation occurs at signing and filing, not at the point of AI use. If a paralegal, a junior associate, or an unlicensed brief writer uses AI and you sign, the document, the responsibility is yours. Supervision of AI use is now a professional conduct issue, not just a quality control one. Fourth, the insurer conversation is coming. Start thinking about your firm's AI use policy before someone external asks you to produce it. We are building something practical for exactly this, a complete verification and supervision system that closes the gap between using AI and being safe using it. More on that soon. LNU versus Blanche was decided 6 days ago. The Oregon record was set weeks before that. These are not historical case studies. They are happening now to lawyers who are using the same tools you are using in the same practice areas you work in. The profession is not going to stop using AI. The panel would not recommend that it does. But the lawyers who are going to use it well are the ones who understand where the line is. The line is not at the point of research. The Ninth Circuit has told us exactly where it is. It is at the point of signing and filing. For now, at least. That's the episode. See you in the next one.